The bond is the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to the jail now.
Why am I being arrested?
Take her down to the jail now.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. You are violating your oath, Mr. Ayarochi. Also require the indemnity bond, and I'm going to require the other bonds.
This is not a discussion here. This is not a conversation. I ask a question. You respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
Before this even becomes a legal discussion, it turns physical. The judge states clearly that the warrant is being executed and orders her taken into custody. That means this is not a surprise arrest. It stems from a previously issued warrant, most likely tied to failure to appear. When someone turns themselves in on a warrant, the court has full authority to execute it immediately. Her repeated demands, "What crime have I committed?" And this is kidnapping, show a fundamental misunderstanding of what an active warrant legally represents. Once a warrant is issued for failure to appear, custody is not optional. The judge is not debating, she is enforcing an existing court order. The moment she begins resisting verbally and physically, the courtroom dynamic shifts from procedure to control.
City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It is now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She is in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed that.
Well, your documentation that you filed, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
This is a critical judicial boundary being drawn. Courtrooms are structured environments, not open debates. When a judge asks a direct question, especially regarding failure to appear, the expectation is a direct answer. Instead, she redirects to questions about case numbers and rejected filings. That shift is significant. Rather than addressing why she missed her bench trial, she pivots to procedural grievances. Judges recognize this pattern quickly. The issue before the court is simple. She was notified there is a signed receipt in the file and she failed to appear. Everything else is secondary. When a defendant attempts to control the questioning, the judge must reassert structure. That is exactly what is happening here.
I need the oath and bonds to be put for each person acting as a public official, in this case, who is acting as a public servant, to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. Please, for the record, let it be known that you exited.
I did. I exited the courtroom and asked the police officer, probation officer.
Who has the indemnity bond?
Thought so.
Where's the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail now.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. No, this is a false arrest. This is kidnapping. They're violating my rights, my constitutional rights. I put in.
I thought the Constitution didn't apply to you.
The Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
We will go on the record in the matter 24 FO 275, Town of Menon versus John Armstrong. The Town of Menon appears through Chelsea Whitley by video conferencing. She was on her way to court to be here in person, but the weather is now in a terrible state and she had to turn around in luck because she could not get here safely. So she's appearing by video. John Armstrong appears here in person without counsel. We're set today for a court trial. But before we begin, I do have to bring something to everybody's attention. Mr. Armstrong, I believe I need to recuse myself from this case because it's been brought to my attention that there's been numerous postings that you believe that I'm biased and I'm not partial, or that I am partial and I'm not impartial, and you don't believe that you're going to get a fair trial and all of these things. And I'm going to tell you that my whole job is to ensure that people can get a fair trial, and that's my job. And also, I also want to let you know that courts don't decide where people live. Courts don't decide where people go after they're done with probation. Judges don't decide that. People don't decide those kinds of things. I don't get to make that choice. And so those are things that I think that people should be more informed of the justice system and know how it really works before they spew things all over, because it's not fair to the people who actually know how the system works. And so I don't care what you say or what you said about me. I really, truly don't. It doesn't hurt my feelings. It's my job. But I want to let you know, and I'll let you in on something that I didn't find out that I had a group home 3 houses down from me until I got a case where there was a shipment, a huge box shipment of THC vapes sent, and I was on that case. But you want to know what? I had to dismiss that case because somebody's constitutional rights were violated. And so as a person, that kind of, I'm like, wow, I just found out I have a group home like 3 houses down from me, and there was a shipment of THC vapes sent to this group home. As a person, I'm like, wow. As a judge, I have to look out for people's rights and their constitutional rights. And that person's constitutional rights were violated. And it is my job, my responsibility, my ethical duty to dismiss that case because that person's rights were violated. And that is exactly what I did. That is exactly
Understandable.
what I do.
This may be a lot different than vapes, though.
Well,
Yeah.
the thing is, I'm not going to get to know because you have already stated on social media, and again, it's been sent to me by multiple sources, that you think that you're
Notice what triggers this comment. The judge references documentation filed without a proper caption or case number. That is often associated with sovereign citizen-style filings, unconventional paperwork, demands for bonds, challenges to jurisdiction, and refusal to engage directly with the charge itself. The defendant denies claiming that label, yet the behavior aligns with it, requesting oaths, indemnity bonds, and public servant credentials instead of answering why she missed trial. Courts evaluate conduct, not labels. Whether she self-identifies that way or not, the filings and arguments reflect a strategy that attempts to undermine the legitimacy of the proceeding rather than contest the traffic citation itself.
not going to get a fair and impartial trial.
Yeah, I sent that letter away when it started. I sent that letter to you.
Well,
As a matter of fact, I sent you a letter 2 years ago that you never replied to or never responded to.
there's such a thing called ex parte communication.
Understandable.
Where judges cannot respond to things by individual people. And there are, in cases, only some people can write letters and do some things. I can't respond to letters that are sent to the court and to be put into a file. I would be able
Understandable,
to respond
yes.
here if we have an actual trial and as a judge. That's where my voice gets to be heard. I don't get to be heard until that time.
I guess I was sending it out for public awareness. I sent the letter to 3 judges and I got a response from 2 of them.
Well, I don't know.
So here we are. So
I'm going to guess that, well, I don't know. I can actually go and talk to those judges because I'm friends with all of the judges in District 10.
well, I've also brought a witness that he said the state asked for 9 to 12 months and he was out in 3 months. And there were 2 roommates
Here's the thing.
that are pedophiles in his house.
Here's the thing that you don't understand about the law. There are higher courts that direct what courts have to do and what I have to follow.
Yeah. You're not getting all the information.
I know I'm not, and neither are you. And that's what I'm saying.
I've got
and that's why I'm saying I'm recusing myself so you can have the fair and impartial trial.
Thank you very much.
Believe that you.
This is a classic jurisdictional diversion. Requests for indemnity bonds, official oaths, and proof of authority are frequently raised in sovereign citizen-style arguments. The theory suggests that public officials must produce personal surety bonds before acting. In reality, courts operate under statutory authority, not private contract law. Judges and prosecutors are empowered by state law and constitutional appointment, not by producing paperwork on demand in open court. The key point here is procedural relevance. None of these bond demands answer the question of why she failed to appear. When arguments move away from the charged conduct and toward abstract authority challenges, judges typically shut it down quickly, as we're seeing here.
And so you'll be assigned a new judge, and then you can have the fair, impartial trial that you wish to have. And however it goes is how it's going to go.
Will I be able to request a jury trial?
No.
Oh, because I requested that earlier.
This isn't a jury trial case.
But I requested it initially. I requested a jury trial.
But it's not a jury trial case.
On the letter from the court said that I had an option.
To the new judge, and you can make your case
Perfect.
with the new
Thank
judge.
you. Thank you very
And
much.
so that's what's going to happen.
Yes.
But again, it makes it very difficult for the justice system when people don't understand how it works and what happens. I would love for you to come and sit in court, not only my court, in every court. Go sit in Polk County Court, go sit in Washburn County Court, go sit in Barron County Court, and see how courts function and how they work.
As a matter of fact, I was sitting here for Randolph Peckman's sentencing that he didn't show up for.
That wasn't my case.
Yes, it was. You were.
It was John Anderson's case.
He didn't show up.
It was Judge John Anderson's case.
And so there was a warrant out. The warrant got squashed, and then the charges were dropped, and he's back in the house, and the windows are boarded up.
You can go and look at the back. It was Judge John Anderson's case because he took that case. So, know the facts.
Okay, well, thanks for your time.
I issued the warrant, yes, because he didn't show up. But that's what happened after that, because I issued the warrant because he didn't show up.
Yeah, I actually gave you his address in court because you didn't have it. And so I asked Finch the next day if a warrant went out.
This exchange is revealing. She asserts that her constitutional rights are being violated, yet moments earlier she was questioning the court's authority. The judge's remark highlights a contradiction. Many sovereign-style arguments claim exemption from statutory systems while simultaneously invoking constitutional protections when convenient. Courts function within constitutional frameworks. If someone argues that government authority does not apply to them, that argument undercuts their reliance on constitutional safeguards as well. The judge's response is subtle but pointed. It signals that rights and obligations operate together. You cannot selectively accept one and reject the other when it benefits your position.
She said no, she had heard nothing. And then 5 days later, the warrant finally went out. Meanwhile, he was gone across the country. This is.
I issued a warrant. That's all I can do.
Yeah. Well, who squashed it?
First of all, it's not squash. It's called quash.
Oh, okay. Well,
Quash a warrant.
I got a message from.
Again, follow the cases. Come and sit and follow all of the cases, and then you can learn the information. I don't know what's going on here because I don't know anything, because that's
Of
what
course,
I do.
yes.
My job is to sit here and to hear about your case and to hear about from town of Benon.
Yes.
I know nothing about what's going on in this case. I know there's a citation. That's what I know.
Thanks for giving me the opportunity. I was able to watch your video the other day, and respectfully, I feel for you guys. What I got out of it is that silence is cancerous and it's deadly. And that's what's been going on for 2 years. Silence. I've been silenced by everyone.
Well, you're going to get your chance to be heard, and
Thank you so much.
you're going to have a new judge, and hopefully it's going to take place soon. So Ms. Whitley, I will get the documentation done, and also though, you need to have it in person. Ms. Whitley should be here in person.
Yeah, I understand the situation. Yeah, I was surprised that court continued today because the roads are terrible.
I'm going to tell you, I've been sitting here since
all day.
all day, and I don't know what's going on.
It's terrible. Yeah. All right, thank you.
Thank you. Thank you, Ms. Whitley.
Yes, I apologize. Thank you.
This hearing never reached the underlying citation. It became about legitimacy. That's common in sovereign citizen-style arguments. Instead of contesting evidence, the focus shifts to jurisdiction, bonds, oaths, warrants being squashed, or constitutional violations without a...
This hearing never actually addressed the underlying citation in depth. Instead, it became a procedural battle over legitimacy, authority, and impartiality. The initial arrest stemmed from a failure to appear after documented notice. When confronted, the defendant shifted focus toward bonds, oaths, constitutional violations, and alleged systemic bias. The judge responded by enforcing the warrant, maintaining courtroom structure, and ultimately recusing herself to preserve fairness after public accusations of partiality surfaced. Recusal does not erase the citation. It simply assigns a new judge. The legal exposure remains. The core issue, the traffic-related charges, will still be addressed under procedural law. What this transcript illustrates is how quickly credibility can erode when arguments move away from evidence and into jurisdictional theories unsupported by statutory framework. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.